All right, we're back. And we talked about some heavy, heavy things. So I kind of want to dial it back, lighten it up a little bit. Okay. So I don't know about y'all, but whenever you watch a movie or watch TV, especially if it's something in your wheelhouse, whether it's your business or something that you're aware of, and you kind of yell at the TV saying that is, oh my God, what are they thinking? Well, there are those moments. And I can honestly tell you my stepson and my husband do not enjoy watching TV with me or movies when there are legal representatives on them. So, and we're gonna I can't wait to have other attorneys on because I really want to get their take on this. But let's just talk about probate and how TV shows like they tend to glorify or really scare you into thinking, oh, probate is this horrible thing and everything stops and you can't do anything and then it's a nasty fight. Well, it does not necessarily have to be that way. Can it be? Absolutely. Do we have litigated estates? Yes. Do I handle those? Yes. However, for the most part, if you have a proper plan in place, you can mitigate a lot of the infighting among family members as to who gets what or what is fair. So I'm going to give you a great example. When you see on TV someone presenting to an individual going, you better take this deal, or, we're going to do, we're going to ring you up the flagpole and we're going to screw you and we're going to say what these horrible things about you and even put you to blame and you won't get anything. And oh, your past behavior will be looked at and dissected and we're just going to run you through the mill. First and foremost, if someone does that to you and you're not represented, get an attorney. Just get an attorney. Okay? Because any attorney worth their price, their fees will tell you one, you are owed a duty of candor and respect. Okay? And yes, I can be forthright with my clients and some prospective clients, and some may not you know particularly like the fact that I am forthright. However, I will tell you what your rights are and I'll tell you what they're not. That is an indication of a good attorney when they tell you what you don't want to hear as well. You don't want just a yes man going, oh, yeah. But also, don't necessarily believe that you don't have a choice. Contact an attorney first and foremost whenever having a question. But secondly, when you have whether it is a will, a trust, when you have a plan in place, and take the little post-it notes or whatever that you have underneath pieces of furniture or artwork or jewelry, and you clearly set that out so that a trusted individual is your personal representative or your executor of your estate, that they know upon your passing, you don't let the gypsies take over the palace. They can say, hold on, we have Jane's wedding ring said she really wants her granddaughter to have it, or, you know, grandpa's watch is going to go to this individual. So with specificity and especially those type of things, that will allow a lot of peace rather than chaos. Because what I have witnessed with individuals is that you'll see where family members are like, oh, I want this furniture. And the person's trying to be nice, going, well, what would you like? And okay. And then they all agree, okay, we're going to ship all of this furniture up to wherever we're at. Say you're out of state. In Florida, a lot of our residents here in Southwest Florida happen to come from another state. Well, they'll agree and everybody's nice going, okay, and we're going to help pay for each other's, we're all going to chip in for the U-Haul. And then when it's time to come for the bill, there's fighting. And a lot of times, and I instruct this to personal representatives as well as trustees, no, I mean, I get it as family, you want to do what's right. No, you do what's in the first and foremost, what is in the best interest of the estate, because you're stepping as the personal representative. You are basically representing as if your aunt, your mother, your whomever who passed away is still alive. You are conducting their business. But prior to that, make sure, first of all, that whoever you will appoint as the personal representative or the trustee has the maturity, responsibility, and the wherewithal to conduct how you want your estate to be administered, how you want it to be dissolved, if it is to be dissolved or continued, if it's a legacy type of trust. You also want to make sure that you're not putting someone in a position where they are all of a sudden being attacked by family because family I'll give a situation. I have a family. The decedent passed away, naming one of the second to the youngest of the children to be the trustee in charge of everything on the trust, and did not want a sister to have any part of the administration of her estate or of her trust. Well, that immediately harbored bad feelings on behalf of the sister, but the sister, then the mother of the kids, who the nieces and nephews that were the beneficiaries, started poking them to infight. And the amount of stress, the amount of litigation, needless litigation, and pain of attorneys and everything to basically say, okay, the trustee is doing everything correct, could have been avoided if at that time, rather than naming someone that puts them in a position that it's going to cause a lot of heartbreak and family members attacking each other, rather than that, why not appoint a friend? And that friend then can be the wall saying, nope, this is how it's going to be done. First and foremost, so you don't always have to pick a family member. You don't always have to pick a spouse or what have you. I assure you that I have seen where, in the event of my death, I would choose my brother-in-law to be my trustee because he is incredible at business. He has a really good heart. He is well trusted among the family, and it would not harbor any ill will among my family because they know he would do right and he would be fair. And also he would be able to step back and say, we're not playing these games. Okay. Sometimes you'll see in TV, and I always get so annoyed, like, oh, we're going to have a formal reading of the will, and this is how it's going to be, and there's nothing going to be. No, probate doesn't have to be that way. It can, yes, an administration of the trust is literally that. You don't go to the court, you're reading of the will, you're dealing with that. But there are certain responsibilities still. Still have to do a tax return for the estate. You still have to get your CPAs involved. You're still going to be paying debts and such, but you're going to ensure that what gets given to the individual is what you want that to be. Because bottom line, if your trust plan is not done right, your will's not done right, and people can poke a hole in that, then the state gets to dictate who gets what by what percentage. I don't know about you. I don't want the state to determine how or who gets what in my family, or it may leave out people. So that's the other indicator. So when you see someone that you'll see like an ex-spouse in a soap opera comes in and goes, I get to have everything. I was married to him and I have right. And nope, you don't. In Florida, especially. Once you get divorced, that means that a divorce basically acts as that spouse predeceased you, and anything that you are leaving to that spouse, unless you do a new will after the divorce, still leaving everything to that spouse, that nullifies it. And if you die without a will, and say, let's just say you were married, you're divorced, you have children from the first marriage, then you remarry and you die without a will, then your current spouse and your children will be entitled to 50% of your estate, and your current spouse will also have a right to the homestead for life and claim a family allowance as well as an elected share, which is 30% of the net assets of the estate. So these are things that you need to discuss. Also, why it is so important that you do get together with an attorney. Yes, there are a lot of commercials of websites where you can get your own trust and you can create it for $150, $250, just plug and play. Even if you want to do that route, pay the money to at least have it looked over by an attorney that specializes in estate plan. I have seen so many things and mistakes that causes a lot of litigation and needless amount of attorney's fees spent that whittles away the amount of money that the beneficiaries would receive. I had one where the gentleman did it. He didn't like attorneys. He wasn't going to do it. He was going to DIY it. No, DIY, do it yourself. So, and he did. And thankfully, he did have 2 witnesses on that will. He literally put up a piece of paper, signed it, and had 2 friends witness it. But the family members weren't convinced of it because it was unusual. It didn't have the typical standard language and stuff, and family members, and he was leaving everything to a girlfriend. Well, of course, that opened up a huge litigation, a lot of attorney's fees. Thankfully, we were able to settle it. However, that wasn't until after everybody was ringing everything. And I mean, the ill feelings and the ill will that it harbored could have been totally avoided if there was a proper will, just even looking it over. So I know this is a deep conversation and we're going to play some fun. And I really am wanting to bring in more television shows. So if you guys want a heads up, check out Lansden, Paramount TV, Prime. I'm obsessed, Billy Bob Thornton, but there's a lot of screaming at those attorneys and situations. So we're going to start talking about that. I am Alina Gonzalez Dockery. I am so grateful that you tuned in to another episode of Legal Talk with Alina. I look forward to seeing y'all in our next episode, and we will be bringing on more guests with more expertise. Wishing you all again a happy new year, and I will see you next time.
This has been a Now Media Networks feature presentation. All rights reserved.